All right, welcome to this explainer. Let's dive right into a monumental legal shift from April 2026. This is a real game changer that is finally bringing justice and, honestly, long overdue financial compensation to Royal Navy veterans suffering from hearing loss and tinnitus. For decades, the legal system just made it incredibly difficult for these veterans to actually win a claim. But recently, historic court decisions have completely rewritten the rulebook. We absolutely have to start by acknowledging the harsh, inescapable reality of naval service. As the saying goes, a sailor on deployment literally lives inside the machine. A warship isn't just a regular workplace. It is a sealed, steel world of engines, gearboxes, and pumps, and it's running 24 hours a day, 7 days a week. It's an environment unlike almost any other occupation on Earth. And the core issue really lies in the stark contrast with civilian life. Think about it. A civilian industrial worker might endure incredibly loud machinery, sure, but eventually they get to clock off at 5 p.m. and go home to quiet rest. Naval service is completely different. A sailor's noise exposure didn't end when their shift ended. Because steel doesn't absorb sound, it actually reflects and amplifies it. Sailors ate, relaxed, and slept inside this resonating steel instrument for weeks or even months at a time, with literally zero downtime to recover. So let's look at Section 1, Life Inside the Machine. This relentless environment creates an overwhelming acoustic load. Veterans were essentially exposed to two overlapping threats. First, you've got the continuous noise. That's the constant deafening roar of gas turbines and the 24/7 ventilation trunking running right through the mess decks, where people were trying to sleep. Then, layered right on top of that, was violent sudden impulse noise. We're talking the concussive blast overpressure from naval gunnery, the absolute scream of jet engines and helicopters on the fight decks, and even close-range weapons training for the Royal Marines. Just a relentless wall of sound. Moving on to Section 2, the anatomy of damage. Now, what experts look for is something called the 4 kilohertz notch. This is essentially the audiological fingerprint of noise damage. You see, the intense acoustic trauma experienced at sea permanently destroys the hair cells in the cochlea, and those are cells that never ever regenerate. When medical experts evaluate a veteran's audiogram today, they look specifically for this distinct drop in high-frequency hearing, right around the 4 kilohertz mark. This notch definitively proves that the hearing loss is a direct result of military service, rather than just the smooth, gradual deterioration that comes naturally with getting older. But here is a massive revelation, something totally huge for so many people. Tinnitus is now recognized as a distinct compensable injury, even if a veteran's hearing test comes about completely normal. For years, veterans who complained of ringing, hissing, or buzzing in their ears were just turned away if their standard hearing tests looked fine. Well, the 2026 High Court ruling legally confirmed that a clean audiogram is not the end of a claim. The tinnitus itself counts as a real standalone injury. Just to put into perspective exactly how seriously the courts are taking this, let's talk about the figure of £19,000. In the landmark 2026 Abbott judgment, one of the lead claimants actually failed to prove his hearing loss was caused by service noise. However, he still recovered this exact 5-figure sum for his tinnitus alone, plus the cost for his tinnitus counseling. So, if you were ever told a normal hearing test closed the door on your claim, well, this ruling changes absolutely everything. Let's move to Section 3, the decades of denial. Now, a primary defense historically utilized by the Ministry of Defense was Crown immunity. Basically, this was a historical legal doctrine originating way back from the 1947 Crown Proceedings Act. It explicitly prevented service personnel from suing the MOD in civil courts for injuries connected to their service. This immunity acted as a massive, almost impenetrable blockade for decades. Historically, this doctrine essentially treated permanent hearing damage as just an unavoidable, inevitable hazard of the job. But the legal landscape began to shift significantly over time. In 1987, Crown immunity was officially removed for future service. Fast forward to 2024, and after thousands of serving and former personnel banded together in massive group litigation, the MOD fully conceded. They abandoned their historical defenses of limitation, breach of duty, and combat immunity entirely. And it was that vital concession that paved the direct path to the historic Abbott judgment being handed down in 2026. Which brings us to Section 4, the 2026 legal breakthrough. The absolute game changer here was a shift in diagnostic standards. For years, the MOD assessed veterans using an old diagnostic method which relied on civilian industrial standards built for steady factory floor noise. But as we know, a warship isn't a factory floor. The High Court finally tossed out that civilian industrial lens because it systematically under-recognized military damage. In its place, they adopted a new High Court standard built specifically to recognize the high-intensity and impulsive noise unique to the military. This finally created a pathway that accurately reflects genuine naval exposure. Let's look at Section 5, Rules for Scottish Veterans. This leads us to a really crucial question. When does the 3-year legal clock actually start for filing a claim in Scotland? There is a very common myth among veterans that you're completely out of time simply because you crossed the gangway and left the Navy decades ago. But actually, the reality of Scottish limitation rules is vastly different, and it's highly favorable to the veteran. The answer lies in a concept called date of knowledge. This is the exact moment a veteran officially learns their hearing injury is significant, that it's linked directly to service noise rather than just natural aging, and that it's due to a failure in protection. Because noise damage kind of creeps up on you over the years, that light bulb moment often doesn't arrive until a doctor or audiologist explicitly makes the connection. So the key takeaway is that the clock only starts ticking when a medical professional connects your hearing loss to your naval service. Meaning veterans from the 80s and 90s, you may still be perfectly in time to claim today. All right, Section 6. How to claim compensation. So, how does it actually work? Here are the 3 main steps. First step, compiling the service history. This involves gathering your exposure data and recovering your specific military medical records, including any of those in-service hearing tests. Step 2 is medical evidence. You'll undergo a pure tone audiogram interpreted by an ENT specialist, using that new military-specific standard we just talked about. Finally, matrix adjustment. This is where compensation is negotiated and scaled based on the date of your discharge. And honestly, the best part? Your legal team handles the whole shebang at 0 upfront cost to you. Now, compensation scales significantly based on the severity of the injury. Mild hearing loss starts around £7,000. Severe tinnitus alone sits between £15,000 and £28,000. And for total deafness combined with severe tinnitus, claims can actually exceed £80,000. Keep in mind, special damages are also available on top of these figures to cover the cost of private hearing aids, which, as we know, can cost thousands across a lifetime, as well as professional tinnitus therapy. It is also extremely important to know that this isn't just for some narrow group of people. Yes, marine engineering and gunnery specialists are obvious candidates, for sure, but this also includes flight deck crews, submariners confined in both diesel and nuclear boats, and even chefs, stewards, and communications ratings who lived inside that exact same steel acoustic environment. It also fully includes Royal Marines who carried combined infantry and naval exposures. The bottom line is, almost any role exposed to this environment, men and women alike, can seek advice under this new, highly favorable legal footing. The legal landscape has fundamentally shifted. The mod's era of blanket denial is over. If the ringing hasn't stopped, neither should you. Please, do not let outdated advice or past rejections hold you back. The diagnostic standards have changed, and those old legal defenses have finally fallen. So I'll leave you with this thought. If you're still living with the permanent daily acoustic legacy of your naval service, isn't it time to finally claim the compensation you rightly deserve?